Welcome back to the Church Law Podcast, where we equip pastors, church leaders, and ministry teams with the tools they need to lead well, both spiritually and legally. I'm your host, Erika Cole, known as the Church Attorney. Whether your ministry is local or global, we believe that wise leadership includes protecting what God has entrusted to you, and that includes your church's name. Today's episode is one that I believe every church needs to hear. We're talking about trademark protection. Yes, even for churches, this legal step can be the difference between operating freely or facing unnecessary risk. I'm thrilled to be joined by my special guest today, Nate Adams. Nate is a partner at Holland and Knight and a leading legal voice for religious institutions. He leads the firm's religious institutions team and serves on its nonprofit and tax exempt organizations team, advising churches and ministries across the country. Nate regularly counsels on everything from trademarks and intellectual property to governance, tax exempt structuring, employment, and religious liberty issues. He also edits the Religious Institutions Law Update and is a church law and tax advisor at large. With experience spanning constitutional law, property disputes, public funding, and ministry mergers, he brings deep insight into how churches can protect their mission and stay legally strong in a changing world. Nate, thank you so much for joining us today.
Thank you, Erika, and thank you for what you're doing for the church.
It really is my pleasure. So, this podcast episode is happening because of questions from our listeners. So, as you likely know, the issues surrounding intellectual property are complex ones. And this can be especially the case with churches. And that's why we're providing this episode on Trademark 101 for churches. So, Nate, let's just jump in and start with the basics. For pastors and church leaders who may be hearing this for the first time, can you share what is a trademark and why do churches need to know about this legal option?
Sure. So a trademark is a symbol, design, word, or phrase legally registered to represent a person and distinguish its goods from those of others. A service mark is like a trademark, but focused on distinguishing the services of an organization from those of others. And there are different kinds of trademarks. There are marks that are simply word marks. Those are standard character formats without regard to font, style, size, or color, just a series of words. And then there are design marks that comprise a graphic design or image with or without wording, such as a stylized logo.
I really appreciate that. And I have to say, clearly, I find value in marks, right? Because I'm the church attorney and that's a registered mark. I think there's some power in being able to brand yourself and people to be able to find yourself as an individual, but also obviously as a ministry. Why would you say that the matter of trademarking for churches has value, right? It's a nonprofit, it's a tax exempt organization. Unlike for profit businesses, of course, they need to be able to make money, but their bottom line is something different. They have a bit of a different purpose. Why might churches find value in this process of trademarking?
Sure. So the simple answer are imposters, knockoffs, copycats, counterfeits, dupes, fakes. These are the reasons why churches should consider protecting their distinctiveness as much as commercial enterprises. To be sure, some might say that it seems sacrilegious as if to commercialize the holy when you're talking about trademarks, but consider the alternative. John Doe is searching for Agape Church in St. Louis and comes across what he thinks is the website. Turns out to be the website of another organization with the same name that has a non-Orthodox theology, non-Orthodox style of worship and liturgy, has Agape Church, the one that he was searching for, advance the Great Commission without being trademarked in that scenario. So the importance of preserving sound doctrine really becomes a strong rationale for trademarking. Associations or denominations of churches also have special reasons to trademark, similar to the manner in which franchisors trademark materials names so that they can control their franchisees, so that if those franchisees don't use the brand products that they're supposed to, don't follow the ingredients, don't have the right dynamic in their stores. Again, what does the franchisor do? It withdraws the name and makes sure that they don't hold themselves out as a member of that association. And of course, again, associations or denominations of churches have similar reasons to do that, to be sure that all of those organizations within their structure have the same orthodoxy that they share.
That's so good. And I mean, I have to say that there are common words that are often used in the church context, right? So I know any number of Mount Calvary's or First Baptist or Agape, as you said, Cornerstone, right? There's certain language that can often be found in the church arena. So, what would you say are the first steps a church should take if they want to trademark their name or logo?
Yeah, so the first thing is, of course, a trademark or service mark cannot conflict with any other mark, and that's simply to avoid confusion. And you're right that in the church world, we have lots of common names, and I always kind of laugh at the first something or the second something. I'm not sure what, began that process, but it seems like, and so there are words like that, first, second, even the word church that cannot be themselves trademarked. They would have to be trademarked in connection with other identifiers. So the second element is that a mark has to be distinctive. Again, the word church is not, but when it can be disclaimed as part of a phrase with other unique words, and then the combination itself still trademarked. The third element is the mark has to be used in commerce. And of course, that happens when churches advertise or buy and sell products. And finally, the mark has to be a source identifier for services. In other words, it must be a proxy for the church, such that every time a churchgoer attends a church utilizing that word mark, a design mark, the distinctive aspects of that church are present. And again, the analogy would be, if you go to McDonald's, you pretty much know whether you enter the McDonald's store in St. Louis or you enter it in Tallahassee, what the experience is going to be like, the types of goods and services that are going to be available. Likewise, when you enter a church with that name, the churchgoer would expect to see that.
Yeah, that's really good. And I think it really goes back to something you referenced earlier, that sort of franchise consideration. And while in the early days of church, I've been in the church my entire life. I consider myself very much a pew baby. So we were talking about the changes we've seen over the years, whether it's sort of that Hillsong kind of brand or whatever church franchise you might want to point to. This is something that we see commonly now, where there are, they may say one church in many locations, right? We see that same kind of similarity in branding across campuses. And I know this may not be for everyone, but I do think that this message of how you at least consider protecting your name is really important. So, what are some of the biggest mistakes that churches make when choosing or using their name?
Yeah, so I actually do think that trademarking is for all churches of all sizes, and conceitedly, the more complex, sophisticated the churches are, the more important it becomes. The more you involve yourselves in a global reach or a national reach, it's certainly very important at that point. But even the church on the corner, I have been contacted at times by a church who discovers that across the street, another institution establishes itself with basically the same name. And so you're going down the street as a potential newcomer to the church, and you've been told, hey, you ought to go try out Harvest. And it turns out there's two harvests on two different corners. And so how do you figure out which one is the right harvest? Well, you got to have really good directions. And of course, one of the reasons for a trademark, a logo, is to provide information to consumers. Just like in the commercial setting, when you go into a store and you buy a can of Coca-Cola, you have a clue before you open up that can what it's going to taste like, because you've had other cans of Coca-Cola and you expect to have something similar. So you can avoid doing the due diligence that you might otherwise have to do before you buy a good or a good or service. And the like thing is true in the faith-based sector. And you're right, when it comes to more complex church organizations that have multiple sites or part of associations, if you go to a Calvary church, you kind of understand, typically what you're going to expect as compared to a liturgical church. And so these names do have meaning. I think the biggest mistake that's made is a church that just chooses a non-distinctive name and logo, and then turns around and wants to have a larger impact than maybe that name will support. So if you are First Baptist Church, and that's the end of the story, you are going to find, probably 700 others around the country that have that similar first three words, and so it'll be difficult to distinguish yourself. Churches, associations, denominations, they have the same reason that Coca-Cola does, to share reliable information about themselves with visitors from a simple name or design mark.
No, that's super helpful. And I do want to just ask this question because I want listeners to have clarity on what a trademark is and what it is not, right? So does registering the church's name with the state, for example, when the church incorporates, does that provide trademark protection?
No, it does not, and I'm glad you raised that. So what you're talking about is a fictitious name for a business, or a trade name for a business, what we would call as lawyers the doing business as name. Many people don't realize it, but the vast majority of companies, when their registration with the state, their corporate registration with the state is not the name that they use when they do business in the world. And so you may have XYZ Corporation, the trade name of which is, Harvest Corporation. And when you go down the street, you don't see XYZ Corporation on the sign, you see Harvest. That's called a trade name, a fictitious name. You can, in some instances, trademark a trade name. But of course, that depends upon whether those elements I alluded to earlier are present, i.e., does that trade name, is it distinctive, or is it just like any other trade name?
Yeah, exactly. So I think it's important that listeners take away from this that what you do on the state level does not automatically translate to matters on the federal level. So when you incorporate your church, so you file articles of incorporation, that assuming that name is available in the state, you meet all the other requirements, you're able to have that name, right? Designation for your legal entity. Likewise, if you then want to have a DBA or a trade name associated with that legal entity, again, assuming it's available, you can do that. What it does not, however, provide is what Nate is sharing with us today is trademark protection, which is something that can only come through the United States Patent and Trademark Office. So I think that distinction is really going to be critical for listeners to know. Now, you mentioned this whole idea of the 700 First Baptist churches, right? We're making up that number, I know, but it makes me think about what happens if another church in a different state has the same name or a similar name. Can both of them legally exist? Like, what happens in that situation?
Yeah, so once you have a trademark name, one of your responsibilities is to police the mark, to make sure that other people are not, in fact, infringing on it. And the way that's done, as you said, you first registered with the United States Patent and Trademark Office. They take you through the process. You only get the registration if you can prove, that your name is distinctive and nobody else is confusingly similar and all those different things. And then you get approved. Sometimes in that registration process, even when you think you have a distinctive name, somebody else will show up at the dance and challenge your ability to actually register it. So that's the first time sometimes these issues come to life. But then there are other times when you've registered, and there's sometimes even an international challenger who was not invited to the dance when the USPTO went through the registration process or wasn't carefully monitoring it, and then sends a cease and desist letter. And it's pretty common for that to happen. Unfortunately, I've been involved with 2 or 3 ministries where a cease and desist letter came the challenger doesn't have to have the exact same name in order to be a legitimate challenger. They just have to argue that your name is confusingly similar. And that can be because the words are confusingly similar. It can be because the graphic together with the words is confusingly similar. And at some point, then the parties have discussions about what happens next. And oftentimes, the party that is the late filer, uh, patent and trademark rights, commonly first to use is an important consideration. And so, depending upon how that shakes out, one party may end up finding that they're required to change their name. And you can imagine if you've been operating an organization for 10, 12 years with one name, and then because of a challenge like this that's legitimate, you have to turn around and start using a different name, it can have a major impact on the organization. So it's always important, if you can, if you first off, do consider trademarking. When you do that, typically you'll want to have counsel assist you in that process to, as best as possible, confirm on the front end that the name that you're then going to invest in and associate with your organization will not be vulnerable to those kinds of challenges.
Yes, absolutely. I echo those sentiments. It's best to do this work on the front end. And I've recognized that sometimes ministries can, the vision can expand and change over time, and maybe the name changes along with it. You may have been doing this work as long as I have, and seen the era where, when I say era, I mean like ERA, right? Of time, the period of time in which churches were rebranding to remove certain indications of denominational affiliation, for example, right? So when church names were, you know, decades, I would say ago, it would be a First Baptist church, just using that example. And now many times you have names that don't have the denominational brand name, I'm giving air quotes, in the name at all. So we were doing lots of articles of amendment, and we were following lots of articles of restatements, like we were doing lots of those things on the state level. And so that could happen over time. And that rebranding not only means that you are changing your name at the state level when you potentially get this new mark, right? Whether by choice or by force, based on the situation you described, you also have to change your lots of other things. So forget things like stationery, et cetera, right? We can do those kinds of things easily, but think about your deed. Think about the deeds to your church properties, for example, and many other areas. So this name change, logo, etc., these trademarks can really impact broader areas. And so I'm glad that we're having this discussion and you're bringing these points to the forefront. So you suggested that and shared one of the critical parts of having a mark is defending the mark. So people have to both manage the front end of this situation where they make a selection of a name that doesn't infringe on someone else's name. And also on the back end, having to make sure they defend their mark is a part of that registration as well. So have you seen cases where churches were forced to rebrand due to a trademark issue? And if so, what can we learn from those examples?
Yeah, I actually have seen parachurches have to rebrand.
Mm.
And, I think in many times this comes up. It's one ministry sending out a letter to another ministry. You might expect that there's a little bit of a different standard than you might see in the commercial world with respect to that. And there is. But at the end of the day, the ministry is still going to insist upon the same result, which is, stop using my name if in fact they're using it. Now, sometimes the challenges are, can be dealt with because there's a mistake of fact. And when that happens, I have fortunately seen ministries back away from original defensive positions, but I have seen also situations where one ministry challenges another in its use, and it goes to peacemaking, Christian peacemaking. which has been interesting in itself too. That's a whole other discussion. But at the end of the day, yeah, the question is going to be, what's the reach of the organization? I should hasten to add that even when you do not register trademarks under the common law, there are intellectual property rights that arise simply by usage. Now they're limited. So, for example, you've probably been around town and seen the same name assigned to different kinds of businesses. John's Tree Service, and then down the street, there's John's Bakery. How could it be that there are two Johns? And how could it be that in such close proximity? And of course, under common law, John's Bakery does probably have priority of usage for that name in the geographic region where it's located. And the reality is that not too many people will confuse John's Bakery with John's Lawn Service. Yeah. And so, both of those can coexist even in a similar proximity. But the real challenge is, okay, well, now what if across town, John's Bakery comes into existence owned by a completely different set of actors? You go to one side of town and it's one owner, you go to the other side of town, it's the other owner. Under the common law, can those two coexist? And it becomes a difficult litigation in that context, because the two sides will want to distinguish their particular geography for one another. And it just becomes a question of first use, geographical and confusing dissimilarity, which has to be litigated. Now, if instead John's Bakery had gotten a trademark to that name, then there'd be no question who has priority of use. And that's why in the faith-based context, these issues also arise with churches located across from each other with similar names, or in the same town with similar names. Sometimes one accuses the other of not being orthodox, and those are probably the most challenging circumstances.
Wow. Well, this has been an empowering discussion, and as we prepare to land the plane, I just want to ask you one final question. Um, can protecting a church name be seen as good stewardship of what God has entrusted to the ministry? I
So
think
I think
everything that
that's
you've think that everything that you've said has led to that. But if you agree with that, which I think you do, how would you say?
Yeah, so I think that's the softball question for sure. It's stewarding resources to trademark, again, because you want to protect sound doctrine, because you want to ensure that the resources that have been expended at your church, furthering the purposes of your church, continue to be furthered in a way that will not be confusing to other people if they see a similar named organization down the street. So all of these things are core, I think, to just doing ministry well.
Fantastic. Well, this has been such a rich conversation, Nate, and thank you so much for sharing your expertise and your heart for the church and joining the podcast today. I've truly appreciated, and I know that our listeners will benefit. And to our listeners, sorry, go ahead.
It's been my pleasure, and I also thank you for the important work that you're doing for the church.
Thank you. It's a pleasure. And to our listeners, if today's conversation confirmed that it's time to start taking legal protection seriously for your ministry, and you desire to act, we will include Nate at Holland Knight, his information in the show notes. And also, I want to just use this moment to invite you to join the Faithful Foundation's membership. It's a one-of-a-kind membership designed to specifically support church leaders like you. Inside, you'll get the tools, templates, legal guidance, and support you need to lead with excellence and stay in alignment spiritually and legally. You don't have to lead alone. Learn more and join today at erikacole.com. And also, I want to just announce, if you haven't heard, the 18th annual Church Compliance Conference is officially happening virtually on September 18th, 2025. So save the date for this can't miss event for church leaders, finance teams, and administrators who want to stay ahead of legal dangers and protect their ministries. Save the date and get the details at erikacole.com/church compliance conference 2025. Thank you again, Nate, for being with us. And thank you, listeners, for tuning into the Church Law Podcast. Until next time, it's my prayer that you stay covered by grace and protected by wisdom.